Good afternoon, everybody. My name is Chris Justice. I'm an employment lawyer with Samfiru Tumarkin. And as always, I'm here today to hopefully answer as many questions as I can within the time allowed. So if you've got any questions regarding maybe a contract that's been put in front of you, maybe you've been let go or you've lost your job, or something's going on in the workplace that you're wondering about, maybe you have some questions, definitely feel free to get them in during today's session. And as always, I'll do my best to answer as many as I can. So I usually start off with a bit of a case of the day or news of the week just before some of the the questions come in. This time around, I wanted to talk a little bit about the Pay Transparency Act. This is something that applies in Ontario. And so starting January the 1st of this year, job seekers, people looking for work, they now have the right, in a lot of cases, to see salary information regarding a particular job posting. And so there was the Pay Transparency Act that was put in place with the main goal to do just that, to provide some transparency as far as some of the hiring practices that go on, as far as giving people more information about the job, in this case, regarding wages for the most part, before they apply so they can get a sense, as well as some other things that I'll quickly go through. So basically, the rules as far as the Pay Transparency Act are concerned, they will apply for the most part only to employers that have 25 or more employees. So it's going to be obviously more on the larger side in terms of the company. And it can also, that said, it can apply to an employer that lists a job posting as being help wanted. So if they don't give any specific role or project that they need help with, and it's more of a general help wanted ad, then in those particular cases, even if you're smaller, there may be some regulations you're subject to. But yeah, basically it just looks at companies, making sure that companies provide the salary range. The range itself can't be any greater than $50,000 unless the job that's being posted for or being advertised is over 200,000. Then they can do a bit more of a wider job range. But otherwise, there needs to be specific salary or hourly rate. And again, if they're going to do the range, it has to be within a $50,000 amount for the most part. That's not the only thing, though, in terms of the wages being disclosed. Employers in Ontario are now going to be required to sort of provide transparency around non-discretionary pay. So things like guaranteed bonuses or commissions or any other sort of fixed amounts on top of wages. Employers now have to give more clarity towards those ends. There was also a piece mentioned in the act that deals with AI. So basically there's, job applications these days that are more and more being sort of filtered out through AI programs. And if the company is going to use this type of technology to sort of screen and filter the candidates that have applied for the job posting also has to disclose the use of this AI. So whether it's for screening resumes or it could be for ranking applicants or candidates as far as like who's number one on the list and so forth. So they'll have to provide some transparency and clarity up front with the job posting to touch on those AI aspects if there are those involved in the sort of the sorting of the candidates. So you've got wages needing to be disclosed with maybe a bit of a range. You've got AI and sort of filtering technology being disclosed. There's also some more protections being put in place as far as there not needing to be what's called Canadian experience to work in a job in Ontario. So an employer now can't generally ask you if you have Canadian experience, if you have work history that is specific to Canada. So this will apply for any job posting or any job application forms. So there's a bit more, as I say, protection given there. That said, of course, you apply for a job. A lot of times you don't get it. You may be wondering, why didn't I get it? And you may want some more clarity or transparency there. The regulation also addresses this in part, where if you do apply for a job, and particularly if you get to an interview stage, or maybe you've gone through more than one interview, and you don't ultimately end up getting the job, then the Transparency Act will say that the people who got interviewed have to be notified within 45 days of their last interview, and it has to be communicated in writing or in person. So this is hopefully supposed to address situations where you go through this interview process and you don't really hear anything from the employer after that. You're sort of ghosted and you're wondering what exactly went on. It's in those particular situations that this Transparency Act will hopefully look to address. And there's one other thing I just wanted to touch on about this new act that's come into place. There are consequences if the employer doesn't comply with the act. So if there is a violation as far as maybe the wage transparency not being there, or they don't mention anything about using AI to filter out candidates, or they don't get back to you within that 45-day period if you've gone through the interview and you haven't heard anything as far as the job, then employers are at risk now, so more than ever. So they can be subject to employment standard complaints if there's a violation. There can be inspections done by the government. They can step in and look into it. And ultimately, there can be an order given by the government to either comply with whatever it is that's being breached, or face the consequence of penalties by way of sanctions or monetary amounts. So this can hopefully, again, add an extra layer of protection for employees or potential employees when it comes to sort of issues with pay or misclassification or termination issues. I'll get into a little bit about severance pay, the difference between Employment Standards Act and common law if I have time, but I do want to get into some questions. Appreciate those who have written in with your questions. So I've got one from Jimmy on Facebook who's asking whether being constantly bothered or being constantly disciplined at work is legal or justified, even or especially if it seems excessive and unreasonable. So there does definitely come a point in time where enough's enough. So if someone's being bothered at work, we'll just start with that. It'll depend on what the bothering issue is. If it's an issue of harassment, certainly that's something you're going to want to raise with the company. They usually have processes in place to formalize a complaint. You need to do that generally first, because otherwise the employer could turn around and say that they never thought it was a big deal, or they didn't know about this part of it or that part of it. So you want to go through that process if you can and submit that complaint. Depending on how the company responds to the complaint could mean there's an issue of a potential termination going on there, or a constructive dismissal. It'll sort of depend on how the investigation gets handled. So that can kind of be one example where being constantly bothered, especially after you've put in the complaint, can lead to a constructive dismissal, can create a toxic work environment. And of course, employers have to ensure that their environments are, free of any issues like that. Also, constantly being disciplined at work, it again depends on the context. I think that there very well could be a situation where an employer is being either very nitpicky, or they're just disciplining somebody based on things that aren't true or that are taken out of context. And now that's going on the employee's record. And sort of much like the issue with being harassed or bothered, if this becomes a pattern where you're being constantly disciplined for things that very well may be unjust or unfair, then again, that could be tantamount to a constructive dismissal. That could entitle you to treat the employer's actions as having been essentially a termination, a breach of your employment, which could give you the option of exiting that situation and going after them for your full severance, rather than constantly being subject to potentially unfair or unjust discipline. and or harassment as well. So especially if it becomes excessive and unreasonable, that's where you're going to have probably more leverage. That said, it's always good to give us a shout, get some legal advice, just so that you can kind of go through with the lawyer sort of the chronology of things, what was said maybe between you and the company. And if anything, the lawyer can take it there and maybe continue on the conversation with the company from that point, or potentially escalate the matter to that point of constructive termination or dismissal. I've got another question in from Karen on Facebook, who's saying that their employer has significantly increased the workload of some of the employees, about 3 times as much workload, without any pay increase, and other employees are not affected. They dismissed my request for compensation by citing my contract. Is an employer allowed to increase my workload substantially for a specific group with no adjustment or justification, or could this raise legal or employment standard concerns? Yes, to the last question, it could raise legal and or employment standards concerns. Generally, an employer is not able, legally speaking, to increase the amount of hours you work without your consent. So there's got to be some kind of a contract in place that would speak to their ability to do that, or it could come by way of maybe consent through verbal means, sort of depends there. But if they don't have your consent, and especially in this case, you're working 3 times as much without any pay increase, that could be as well, like the other question, a situation where there's a constructive dismissal. Especially because if it's not in a contract or not something you consented to, and you've been just consistently working a certain number of hours each week, that gets sort of arbitrarily tripled. And there's no pay, so you're not getting any consideration or compensation going your way for that extra time. Then to me, that looks like a constructive dismissal. It looks like a breach of the terms of employment that you have with that employer. And it seems like you've tried your hand at maybe working around it, maybe getting a pay increase, but they've come back and said no to that. So this might be a point where you may need to engage a lawyer, and hopefully with that come to a resolution early, or, God forbid, if you need to, necessary evil may take further action following. The other point you mentioned about it applies to some employees but not others. You may not be suggesting this, but obviously if there's differential treatment being applied to some but not all, the question is also why is it us and not them as well? There could be a possible human rights issue, violation, depending on if you can establish the reasons for the difference, whether it's on gender lines, racial lines, could be anything but something referred to in the Human Rights Act itself or the code. There could be another avenue there too, and another layer of risk for the company if there is that sort of discrimination. So it does seem like it's gotten to a point now, like where I said, you probably need to get a lawyer involved. So we can definitely take you through that and figure out basically all your options and sort of go from there. I've got another question in. This one's from Eric on Reddit. If HR says that a complaint is confidential, but then my manager clearly knows it was me, do I have any recourse? Yes, certainly you do. The issue there becomes whether the company is going to retaliate against you as well, or act in some way of reprisal. Obviously, the basis for having confidential complaints is to allow that person to kind of clear the air or get what's on their chest off it, and supposed to promote more fulsome disclosure within the workplace, knowing that it'll be kept confidential, again, for fear that there could be retaliation. So if somebody says that a complaint is confidential, or in the company's maybe policy when it comes to complaints, it's mentioned that complaints are kept confidential, then there could be very well a violation of that policy or the terms of employment either way. And then I'd add on top of that, if there is retaliation, or the manager in this particular case starts to engage in some form of bad faith or there's a change in sort of the tune to the manager, then that could also be problematic, because even when complaints are not confidential, you cannot retaliate against someone for exercising their right, or just to put forward a complaint. Otherwise, you're going to be at risk of also there being a possible constructive dismissal here. You're at risk of potentially being in violation of the legislation, and the government could also possibly step in if that's an avenue to explore. So it does seem like there's a lot going on here, and it does also seem like you do have recourse. There could be at least 2 or 3 options potentially available to you in terms of how you'd want to proceed moving forward, whether it's yourself or through legal counsel. So again, I'd recommend you give us a shout, and we can set up a consultation and discuss with you. I've got another question in from Roanne Oakes, who's saying, when can you consider an annual bonus as part of your salary? So it's a good question. Obviously, a lot of times you start a job, you understand what your base pay is, benefits, but then there's this bonus program. And some bonuses are essentially guaranteed. Other bonuses are, I guess what they would call discretionary, or maybe based on achieving a certain set of metrics. So I think if the metrics, if the situation is one where you got to meet a certain metric or threshold, the idea would be to show that those metrics have been met, and to show that bonuses in the past have been paid out on those sorts of metrics. Of course, there could be a situation where you don't meet the threshold, and maybe there's an off year. So it's not to say that just because you received maybe 3, 4, 5 years of bonuses consistently that it's a guarantee, but that sort of more so relates to the idea of the bonus being based on some kind of a standard. If there's no standard, or it's a bit more loosey-goosey in terms of how it's calculated, and they just say that it's a discretionary bonus, but you have been receiving a bonus year on, year out for several years, then I think you do have more leverage to say that the following year you should still be expecting that bonus, and that it would effectively become part of your salary. Not to say that the company can't turn around and deny you the bonus that year, but it'll be harder for them to justify it. And if the bonus does represent a big part of your overall package, by denying you that bonus unjustly, that can also trigger a constructive dismissal. And then you would have the option to basically say either, okay, I'm going to let it lie and just keep working, or say, no, this isn't fair for XYZ reason, and it makes up a big part of my overall compensation. So the amount that the bonus makes up of your compensation can be a relevant point as far as whether you have more fulsome legal recourse against the company. So for example, if you are making $100,000 a year and your bonus is $5,000, and the company denies you that bonus, as unjust as it may be, that may not trigger the threshold for constructive dismissal. But on the other hand, if the bonus is 20% of your overall pay and it's denied unfairly, then, in most cases, if not all, it's going to be deemed a constructive dismissal. So that kind of addresses the bonus when it's calculated on metrics, and then when it's calculated on sort of a loosey-goosey discretionary basis. One, you don't have as much leverage depending on how things pan out, and the other, generally speaking, I think you do, especially if you've got a history of getting bonuses. The last option is just if the bonus is guaranteed. So in that case, that's probably the easiest. That would be considered a part of your salary, unless there was some sort of new contract or something put in place that you agreed to that altered it in some way. Thank you for your question, though, Roanne. I've got another one in from Aileen, who's saying that their sister was just let go from her job after requesting parental leave. They told her it was performance issues and they'd only give her 2 weeks. Feels like discrimination. What can she do? So yeah, I mean, there is possibly a slight chance. I would say it's probably slim, but a slight chance that the timing of the termination was just more coincidental than anything, and that there are legitimate performance reviews that are not in any way connected to her having taken or requested a leave. But of course, there is the big risk that just based on the look of it, if somebody's asking for parental leave and then a day or a week or two later they're let go, it definitely looks on its face like there has been some reprisal, retaliation, some form of punishment for having asked for that leave. And if that's the case, then of course the company is going to be in hot water as far as discrimination. So not only would your sister be looking at hopefully getting as much severance as she can, just for having been let go, but also additional damages for human rights discrimination. You would just have the onus of proving that there was discrimination, and it would be on them to show that it wasn't. So it depends on, in terms of the performance issues, what kind of a history there is there. Have there been warnings in the past? Have they threatened, in so many words, termination if the performance issues don't improve? Are the performance issues even legitimate? So I think they would want to distance themselves from this notion that there's discrimination by showing a court or a judge, no, this is why it was happening. Maybe we already made the decision to let her go before she requested the parental leave, but a lot of times that's going to be easier said than done in terms of proving. So I would also suggest you give us a call. At least we can kind of flesh out the situation, lay out the options, and find out what makes the most sense. But I can certainly appreciate you thinking that just sort of based on the timing and it looking very suspicious. I've got another question in from Ben, who is saying the manager keeps denying their legally protected leave requests, but approves others. Is that allowed? Short answer to that would be no. If you've got protected leave requests, which I'm assuming you're meaning leave under, let's say, the Employment Standards Act or some piece of legislation, like in the other person's situation, a parental leave, maternity leave sort of thing, as an example. If you're being denied those requests, then on its face to me, that seems like a violation of the legislation. So you could potentially involve the government, the Ministry of Labor, as far as the violation of the act, or you could go down the path of potentially bringing a claim or a case against the company for the denial of these requests. And depending on the nature of the leave, again, that could involve discrimination, human rights issues. There could be an overlap there. So it's not just a violation of the legislation around employment standards, but also potentially human rights. And that could also basically culminate in another constructive dismissal. All of that would be to say that based on all of those violations, there would be a constructive dismissal. It's not something that people have to stand for. They can draw a line in the sand, especially if there's been a violation of an act or a piece of legislation. And so you could, on its face, based on what you're saying, treat that as though you've been terminated, especially if there's as well a history of denying you these leave requests. It looks like there's been more than one. So there does seem to be a lot of problems going on with this company, with this employer. It doesn't seem, based on what you're saying, that they're doing much right. So I definitely recommend you give us a shout, and we can probably take the reins and look to get what's owed and deserved your way. I've got another question in from Fox on Reddit, who's saying they booked off Victoria Day, but worked the shift prior and the day after, but still claim I'm not eligible for holiday stat pay. How do I know if I'm eligible? Well, one, just as sort of, I'll give you an option of, or an idea of all the options. So you could get a lawyer to advise. You could contact the Ministry of Labor to advise. Usually, anytime it comes to a violation of employment standards, whether it's the Ontario Employment Standards Act, could be the Canada Labor Code. These are things that are going to speak to stat holiday pay, protected leaves of absences, etc. Because those are mentioned in the legislation, the Ministry of Labor is one a person or a group of people that can at least advise you as to your rights under the legislation, or to advise if there's been a violation. They won't be able to give you more fulsome legal advice in terms of what you should be doing. They can generally only speak to whether there's been a breach, and that's something that they can look into and investigate. I do always caution people that before you start a complaint or a claim with the Ministry of Labor for a violation of something, probably better still for you to get a lawyer, at least on the phone, to talk to, because once you commence a complaint under the Ministry of Labor or through the legislation or the act, you're not generally going to be able to go back later and possibly sue the company for that same breach or that same violation. So as nice as the ministry is as far as contacting and maybe getting a bit of information from, you just want to sometimes hold the reins on proceeding with a complaint before talking with a lawyer, because sometimes it may actually be to your benefit to go through the ministry only. But there's many other times where it's more to your benefit to get legal advice and possibly commence a lawsuit or an action against the company for those breaches. So they can kind of be done in one area or another, but not just generally both at the same time. But anytime someone's being denied holiday stat pay, I mean, I don't know what the employer, what their justification is. But if there's been a breach, then they're going to be in some hot water, not just in terms of you potentially going after them or seeking sort of restitution or damages from them, but also the ministry, the government potentially coming into the workplace, investigating and possibly, issuing some kind of a citation or an order to comply or even a penalty to pay a fine. So I think if anyone actually out there has questions about stat days and what's a stat day and what isn't, we do also have on our website, Samfiru Tumarkin's website, we have a lot of blogs and research that's been done, and you can just do a quick search for holiday stat pay. And our website actually has articles where it will detail all the applicable holiday stat pays. And I think it's something we do every single year, just in the case that the days shift from year to year a bit. So I'd also consult that for you and anyone else that's curious. But having said that, those are my questions today. Thanks everyone for the questions. I think I answered them all. We do this often. So if you have a question that didn't get answered today, by all means, tune in at a later date. We're running sessions, not just with myself, but others. You see down below there, this Tuesday, which is tomorrow, in fact, with Karen. She'll be on board for answering any further questions, employment law related. But thanks again, everyone. Appreciate your time today. Do enjoy the rest of your Monday. All the best. Take care. Bye.